to the Reserve Bank and submitting some application. This can be done by the authorized representative, a general power attorney holder. It does not require the services of an attorney in India, although attorneys are also doing this work. So now, accepting that version of mine, the Law Ministry has filed one affidavit in Bombay High Court. The matter was going on in Bombay High Court, and the Government of India has filed one affidavit in Bombay High Court saying that we will be permitting, we have no objection to the, on the point that the foreign law firms can do the transactional work in India. However, and we will regulate. Regulating means Ministry of Law will register them, and no need of registering with the society. Silent करके अपने पास रखो. So now in India, and there is no opposition from any quarter. After filing of that affidavit, none of the bar association, because we have made it clear that this thing is good for our Indian lawyers. It may be not good for certain law firms who are doing this work, because they expect one, because why, and they told me that our staff, whom we are paying now 1,000 UK pound monthly, Clifford Chance will pay them 5,000. They will take away my staff. And we will, and once we will not have the lawyers, good lawyers who are trained one, then what we will do? I told I am not concerned with that. That what you will do. I am concerned with the majority of the legal fraternity, which is good for the lawyers at large. What a new lawyer coming from the law school, he will get. And when now about only 2,000 lawyers are employed by the law firms in India, and once foreign law firms are coming to do this work, minimum 20,000 lawyers services will be availed by them. So why I should close that? Not only that, basically we are concerned with the foreign investment in India, the bringing of foreign exchange. What we are seeing today, the roads are widening. How it is being done? It is coming with the foreign investment. So in every country, in Bangladesh also it is needed, in Pakistan it is needed, in Nepal it is needed. So I had discussion with different bar councils and the bar associations, at least with these developing countries. So this is the one issue we want to share, and I will request our Nigerian friend, Nigerian Bar Association representative, to enlighten what you feel about it.
The Nigerian, Mr. Chairman, and my lords, distinguished colleagues, the Nigerian position as to the foreigner practicing in Nigeria has a constitutional backing, but there was a position taken by the NBA last time when we received a request whether to allow non-Nigerians to practice in Nigeria. The position of the bar was that if the foreigner coming has been granted license to do so, then he could restrict himself to that aspect only and only. Now, we also align ourselves with the fact that it is not going to be fair, or maybe it is not going to be in the interest of our young lawyers who are just developing, to allow entry of expatriates or foreigners. So I would say the position taken at the international level is also the same with the Nigerian position. If maybe a multinational company invites you to prepare some documents, you can come as a foreigner, you prepare the documents, but generally it has to pass through the CAC, because you cannot, the deed or the documents you prepare, you cannot stamp it unless the Nigerian legislation allows you. So it is just for you to prepare the documents only. You cannot sign. So I think the Nigerian position is clear on this also. And we marry this position at the international level. For now, we don't allow foreigners to practice. And that was the position taken at our national bar in August. Thank you, sir.
Thank you. Now I will request you please. Come.
Our guests, chairpersons, brothers and sisters. As we are hearing on the issue, what are the problems of the lawyers in the before the bench, and what problem may arise if the advocate of one country goes abroad for practicing. I will not deal on this point in detail, but I will leave a query to consider the problems arising out in our country as well as other countries. 2 days before, a judgment has been pronounced by the apex court that the senior lawyers should not argue the case in detail. They should argue very short before the courts. I think whether this type of the pronouncements, judgments will help the advocates or the litigants, and what may happen if a counsel is restrained to make the argument in detail. Second aspect, nowadays a tendency is developing, I think as in our country, in other countries also, that due to the pendency of the large works, the relief should not be granted, and the relief may be granted in very little cases. We have seen two maxims: justice delayed, justice denied, and as soon as we read this, we again see justice hurried, justice buried. Now the tendency is developing that justice is being buried. That is merely on the ground that the delay in the justice, merely on the ground that there are so many cases, merely on the ground that justice should be given at once. The real justice cannot be denied. In our country, I think in other countries also, the advocates are facing with this problem, that for the disposal of the works in quick, they have no time to go in detail of the case. They have made the criteria, and if the case comes in that criteria, the judgment is pronounced. But if the case does not come in that criteria, that is not analyzed and other aspects are not being considered. My submission is that the advocates the members of the bar should think on this aspect, that where the population is so much, crores in crores, the courts are in less, the justice can be denied merely on the ground that there is much pendency of the cases. The justice should be delivered at once. I think if it is done, it may be very disastrous, very dangerous for the society, and if the common man of the pupil, if the common person is denied from the justice, we can't be able to establish the faith for the justice in them. With this submission, I finish my arguments, and I thank to Mr. Sri Adis Agrawalaji and my other guests that on this point they gave some time to discuss and to see what could be done to face out with these problems. Thank you.
Thank you, friend. You see, actually, there is a misreporting. It is not the judgment that the senior lawyers should not argue at length. I discussed with the Chief Justice of India. Actually, in passing reference, just because you see a senior lawyer, how he is being designated, why I have been designated senior. Senior are supposed to talk less, but really concrete, precise, not lengthy argument, but without any foundation. That they can't tell to a young lawyer or to a, they can't expect this thing because they will just, whatever has been written, they will just read and this thing. But a senior lawyer should be precise. Your time is always short. It does not mean that they have told, don't argue more than 5 minutes or 2 minutes. And in Indian Supreme Court, basically, the job of the judges is very tough. People think, because once they sit, they are having 100, 200 cases on the file per day, and bulky files. And people think without reading, my case has been dismissed. And I'm proud about the judges of the Supreme Court that they know better about the case than the arguing counsel. But as a layman, when ordinary lawyer goes there, he think without reading, he just, when case was taken up, he told dismissed, without giving the opportunity of being heard. And the client has engaged a counsel, he briefed for so many days, and the judge without hearing, he dismissed. Because judges know what in this case. When I started my practice, it took 6 days to read one brief. 6 days. But now within 5 minutes, I can understand what is the point involved. So, this is these judges, and for the judges in Supreme Court actually, in Indian courts, it takes about 6 months to really know. Because in High Court, there is a different system. High Court, little bit they go through with the judicial file when it come to their house to read. And then everything they want to hear from the lawyer. And then they decide. But in Supreme Court, everything they decide at home, they carefully understand the case. If they found that their judgment is wrong of the lower court, and then they check how it is wrong, then they may ask 1 or 2 questions if they are not clear about that, and they decide at the preliminary stage, not at the final stage. So don't worry, we are here. We have to see that proper system is adopted, and that is being adopted. But it looked like that within 1 minute